mentioned, we will start today with an official territorial land acknowledgement. As we commence our meeting today, and we do so gathering from all parts of Ontario, we do so by meeting on the grounds of and the lands of unceded territories of many First Nation, Inuit, and Métis people. I myself am calling in from Scarborough, Ontario, and the land I'm standing on today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. I would encourage everyone to take a moment today to acknowledge and respect the lands in which you are all joining us from. And with that, we will move on with today's session. So Bianca, maybe I'll pass it back to you.
So moving along, we're going to throw it to
oh, I'm sorry. Yeah, I apologize. I was thinking there was a bit more of an intro there, but all good. So with that, we will officially get today's session started. So I'm really excited to be joined by our colleague, Kim Cunnington-Taylor, who is an expert in this space of the Ontario Not-for-profit Corporations Act. I'll allow Kim maybe to speak to some of her experience as she jumps into the content today. We're pleased to approach this on behalf of the sports sector. Myself, as the CEO of Rugby Ontario, this is a topic that is pertinent in my space as the leader of a not-for-profit provincial sport organization. I'm sure it will be very, very relevant for those that have joined us today. So, Kim, I might ask you to start your screen share as we have our presentation slides to refer to for everyone. Just as that's happening, just like to acknowledge that we've set today's plan to be about 60 minutes or so. We'll do our best of content. There's a lot to get through. It's a robust topic, of course, and we want to make sure that we touch a lot of the key concepts and principles of the ONCA and tie that back to what might be really relevant for organizations such as those that have joined us today. We'd love to give as much opportunity to questions from the audience as we can. But we feel that a lot of the content as we go through the presentation will actually address some of the questions, the common questions that we might otherwise receive. So you are all welcome to use the Q&A function within the Zoom platform here. If you have any need to maybe communicate with the panelists ourselves, there is a chat function as well. But we would like to try and keep all questions submitted through the Q&A so that we can monitor and address those time permitting. And then as we get to the end of the actual content, we'll see how much time we have to address more questions. So Kim, I'll just maybe have you advance to the agenda there. Before handing it over to our subject matter expert today, just want to briefly touch on our agenda. So we will use today to introduce the Ontario Not-for-profit Corporations Act. I'm sure by now, many, if not all of you, are in some way, shape, or form aware of this robust subject. It's been something that's been on all of our tables for many, many years and is now in force by way of the Ontario government bringing that legislation forward last fall. So today's session is really about taking you through some of the basics. There is a lot to cover. It is a very thick document. If you were to print one out, as Kim and I have often talked about, I haven't done that, but I'm sure Kim has a few copies sitting behind her. So we'll take you through some of the basics. We'll share some resources. We'll point you to some of the important links that might be helpful as you go away from this session. We'll talk about the Ontario Business Registry, the OBR for short, and what that means for your organization and how that will be useful for you as you work towards your transition to the ONCA. And then, of course, address some of the practical issues that we think will be common amongst our sector stakeholders. So with that, I'd also like to acknowledge that following this session, we'll have some material that we'll share with you as an audience member, a nice takeaway package that we think will really help you and your organization as you work through this process, an ONCA sort of cheat sheet checklist to help you navigate this otherwise complex process. But with that, I'd like to introduce Kim Cunnington-Taylor and hand it over to you, Kim.
Thanks, Myles. Now, I have 3 screens. And so if I'm looking over here, it's because the pictures of Myles and Bianca are on one screen and the presentation is on the other. So I'm a lawyer in Ottawa, and I'm a sole practitioner, but I specialize in not-for-profit and charity law. And throughout the presentation today, I'm going to refer in some areas to the federal legislation and the Canada Not-for-profit Corporations Act, because the transition that the Ontario government has undertaken to move corporations from the Corporations Act to the ONCA, it's a very different process than we followed for the federal corporations. And the Ontario government and the federal government, they've done these transitions for 50, 60 years or more, and they've each followed their own path on how they do it. And so if you've been involved in a federal not-for-profit corporation back in 2010 through to 2014 or 15, you would have gone through a similar thing, but the process was quite different. So we're going to talk about, as Myles said, the process of transition, what you need to do, concepts, and that sort of thing. So I always like to provide resources. Throughout the presentation today, you're going to hear me talk about the ONCA, the CNCA, the PGT, CRA, and so on. And so when you go back to the PowerPoint presentation after this presentation, I want you to be able to identify what those short forms actually mean. So I always put in, this terminology slide here. And constating documents is another term that you're going to hear a lot. And it's important to understand what documents make up constating documents. If you are an Ontario incorporated not-for-profit, you will have letters patent. They might be called letters patent of amalgamation if your organization merged with one or more other organizations, or it could be called something like letters patent of continuance if your organization moved from another jurisdiction into Ontario, but it's letters patent of something. And that's the birth certificate of the corporation. I have many clients that tell me that they don't have letters patent, and I tell them that, yes, you absolutely do. If you've ever amended your letters patent under the Corporations Act, you do that by way of applying for supplementary letters patent to amend. So the difference in the ONCA is that we'll now be talking about articles of incorporation, that's the birth certificate, articles of amendment, that's the amending document. We might talk a little bit about restated articles of incorporation. And if your corporation ends up merging with another organization by way of amalgamation, then you'll end up with articles of amalgamation. Constating documents also include your bylaws and other formal organizational documents like written policies and procedures and governance policies. I include the term board manual and just put an asterisk beside that because a board manual is not necessarily part of the constating documents. It will depend on what's in that board manual. My clients that have board books, board manuals, they will be a binder that has the letters patent, the bylaws, the written policies, minutes, and that sort of thing. Not all of that board manual is part of the constating documents, but it's possible that certain parts of it are. I think it's important. Sorry, go ahead.
Just for the purposes of today, obviously, we're going to be focusing on articles of amendment as we go through this process, correct?
Yes.
Yeah.
We are. Another resource that I like to provide is a link to the actual legislation. In my practice, I have many clients that have they don't know what the corporate legislation actually is. And so it's, and that's quite common. So here's a link to the legislation itself. And then legislation, the way it's drafted is there's always, or almost always, regulations that go with the legislation. The regulations relate to more procedural and operational things. And you learn about regulations by something in a provision in the act that says, hey, go look at the regulations on this. So a good example with the ONCA is the proxies. There's an entire part in the ONCA all about proxies, but it then says something to the effect of, or as prescribed. Or as prescribed is short form for, hey, go look at the regulations, because there's more stuff about proxies in the regulations. So there are 4 regulations that apply to the ONCA. There's a specific regulation all about names of corporation, what's allowed, what's not allowed, what characters are allowed, like slashes and dashes and that sort of thing. There's a whole other type of corporation called a corporation sole. It's very specific. It's not very common. I will not talk about it at all, other than to say there's a regulation on corporation sole in relation to the ONCA. Other important resources that I think will be really valuable to you include the Not-for-profit Incorporators Handbook, which is developed in conjunction between the Ontario Ministry of Government and Consumer Services and the Attorney General's Office. It's been completely updated. The nice thing about the Not-for-profit Incorporators Handbook is it actually walks you through how to incorporate an Ontario not-for-profit corporation, and it has very specific information about how to incorporate a charity, a charitable corporation. So I encourage you to download it and take a look at it. The Ontario Ministry has created a guide to the Not-for-profit Corporations Act. It's also prepared a standard organizational bylaw, which is very generic. We'll get to it later on, but review that with caution. It's very unlikely that you will be able to substitute the current bylaw that you have with the standard organizational bylaw put together by the Ontario Ministry. We're going to talk about the Ontario Business Registry, and therefore I've given you a link to it. And finally, we will be talking specifically about articles of amendment. So I've included a link to the Ontario government's central forms repository. And if I remember correctly, I have put on a filter so that it will go to the articles of amendment. But you're looking for articles of amendment NFPCA. I say ONCA, some people call it Onca, but in this forms repository, it's referred to as NFPCA. And there are instructions and guides that go with the articles of amendment that are really important to download and read so that they can help you when you're actually filling out the form.
Great. So Kim, obviously that's sort of an introduction to some of the key resources that our audience members can refer back to. This topic is really sort of the culmination of a decade or more of anticipation of this new act coming into force, which is now the case. So today we're going to go through a lot of the core concepts and the principles that that people should leave really thinking about. Obviously, we're just scratching the surface on what is a really broad and deep act. So we do encourage people to take the time to review it as it relates to your own organization. But can you start now? Take us through sort of what's happened and where we need to go, and obviously what our audience organization members are going to have to look at over the next 2.5 years, or within the next 2.5 years, I guess I should say.
Okay, thanks, Myles. So the transition itself, as Myles said, and I probably said as well, the ONCA came into force on October 19th, 2021. And most corporations that are governed by the Corporations Act were automatically continued to the ONCA. So there isn't articles that you have to file with the government to get into the legislation like you did federally. So you're already there. Now you have 3 years to transition to the ONCA, and that transition includes drafting and filing articles of amendment with the Ontario government, drafting ONCA compliant bylaws, and possibly drafting and filing restated articles of incorporation. And I say possibly because it would depend on your context, depend on your situation, depend on how many supplementary letters patent your organization may have. So it's not something that there's a yes or no or a right or wrong. So let's get into some basics. We're going to talk about different types of rules in the ONCA. There's no difference between these rules in the ONCA and these rules in the Corporations Act. The Corporations Act has mandatory, default, and on the next slide, optional rules. But again, in my experience, most people are not super familiar with legislation. This is how legislation in Canada is drafted. And so what's a mandatory rule? That's a rule that you can't change. You can't, the act says that you have to have at least 3 directors. If you try to put 2 directors in your articles will be rejected because you can't change that. You have to have at least 3. You could have 5, you could have 7, you could have 22, it doesn't matter, but you can't have less than 3. So you can't change that anywhere in your articles or your bylaws. You're stuck with that. Under the Corporations Act, there was a rule that would be classified as an optional rule. That's the next slide. That under the ONCA, they turned into a mandatory rule. So members are allowed to remove a director from office before the end of the director's term, except for ex officio directors, if there's a special meeting called for that purpose. And at that meeting, the members pass an ordinary resolution to remove the director. So that's an ordinary resolution is just passed by a majority. And that's different from the Corporations Act. The Corporations Act said that the members are allowed to remove a director before the end of the director's term, as long as the authority for that removal is included in the bylaws. And if it is, then you have to pass the resolution by 2/3. We're going to get into down the road in the presentation, these transitionary rules and what if you don't do your transition right now and that sort of thing. So this is kind of something to keep in mind, where now we have a mandatory rule in the ONCA, and the rule is different. It has different conditions than the rule did in the Corporations Act. So if you have a provision in your current bylaws that allows the members to remove a director from office before the end of the director's term, but it has to be by special resolution, is that valid, or do you get the easier kick at the can, if you will, through the ONCA? A default rule is a rule that says, unless the articles or bylaws otherwise provide, here's the rule. Okay, so you look at the rule in the ONCA and it's going to tell you, unless the articles otherwise provide, unless the bylaws otherwise provide, unless the articles or bylaws other provide, which means that you can change that rule in either of those 2 places, this is the rule. So I've included in here the rule about directors being allowed to make, amend, or repeal a bylaw. The default rule is the directors are allowed to do it, but this is a default rule because you can change, possibly add restrictions on what the directors are allowed to do in your articles or in your bylaws. Either place, doesn't have to be both. Another default rule is the term of directors. It says, unless the bylaws otherwise provide, maybe it says articles or bylaws, the term of each director is 1 year. So you can put nothing in your articles or your bylaws and then just rely on the default rule, or you can change the term of office up to 4 years by putting something different in your articles or your bylaws. So you have, this is why it's important to actually read the rules in the ONCA so that you can match up what you're allowed and not allowed to do. Optional rules. This is where you're allowed to do something if and only if you put that thing, the authorization for that thing, in your articles or bylaws, and the ONCA tells you where you have to put that authorization, either in your articles or in your bylaws or in either. Okay. So if you want to be able to hold meetings exclusively by electronic means, so Zooms, Teams, that sort of thing, you're only allowed to do that if your bylaws give you the authority to do that. So if you forget, then you will only be able to have in-person meetings or hybrid meetings, maybe. Another optional rule relates to proxies. So proxies are not automatic. Members are not automatically entitled to vote by proxy. They're only allowed to vote by proxy if you put that authorization either in the articles or the bylaws. And then also relating to proxies, if you've provided the authority in your articles or bylaws to vote by proxy, then you have the option of restricting who the proxy holder can be. So this is kind of like a default rule in the sense that if you don't put anything in your articles or bylaws, then anybody can be a proxy holder, but it's tied to whether or not you're allowed to have proxies in the first place. So all it says is that unless you put something in your articles to require a proxy holder to be a member of the organization, then the proxy holder can be anybody.
Okay, so Kim, obviously, as leaders of our respective sport and recreation organizations, one thing to be aware of is that the ONCA is in effect. And so organizations need to be thinking about that in terms of what act is actually enforced from a legislation standpoint. So obviously on the screen here, a bit of a brief synopsis of the transition process. So what are the key things from a transition standpoint between now and October of 2024 that our leaders should be aware of?
I just want to back up, Myles. Did you say that some of the organizations are in Quebec?
No, in effect is what I said.
In effect. Okay, thank you.
Yeah.
I was going to take me down another road. Okay, if your organization is incorporated by an act in Quebec, then the ONCA doesn't apply to you. That's simple. So transition process, as I said, there's no formal transition process. You don't have to file articles of continuance with the Ontario government like you had to for federal corporations. There's two slides here that I've mixed up the order. So it is going to appear a tiny bit disjointed. All right. What if you do nothing? If you do nothing, and this is really, really important. If you do nothing, then except for a couple of exceptions, because there's always exceptions, your constating documents, that means your articles, your bylaws, your written policies, they're going to be deemed to be amended to the extent to make them compliant with the ONCA, okay? And that's really problematic. You get to November 2024, you haven't done anything. Your bylaws, you're reading your bylaws to set up your next annual meeting. You're following your bylaws. And how do you know that the Ontario government has actually amended your bylaws on you? You're not going to get any notification or anything. It's just a matter of law that that's going to happen. So you need to be really careful. Using the removal of directors as an option, as an example. Right now, if you've done nothing and you have a provision in your bylaws that says the members can remove a director before the end of his term, as long as, at a special meeting by special resolution. Well, if it's November 2024, the members can simply at a special meeting called for that purpose, kick out a director by passing an ordinary resolution or by a majority. So that's a deemed amendment to comply with the ONCA. Until October 18th, this is where these transition provisions in the ONCA are so crucial. So you can't just cut over and say, boom, October 19th, 2021, you're all under the ONCA, and now all the rules of the ONCA apply to you. They have to give you time to clean up your stuff. So in these transition provisions in section 207 of the Act, until October 18th, 2024, if you have something in your bylaws that doesn't comply with the ONCA, but it did comply with the Corporations Act, then that's okay. You can continue to utilize those provisions until you finish your transition. Now, having said that, if you have something in your bylaws that didn't comply with the Corporations Act to begin with, well, it's still invalid, right? Because if it's not valid under the Corporations Act, the ONCA is not saying through this 3-year period that, oh, you know, we'll forgive you and it can be valid. That's not the case. Your provisions have to be in compliance with the Corporations Act for them to remain compliant under the ONCA for this transition period. And this is where I've messed up the order of my slides. The changes, once you update your bylaw, do your articles of amendment, then your changes have to be approved by the board and the members. And so when you're developing your timeline for the transition, I always tell my clients to look at their next annual meeting of members and then work backwards, I would say about 6 months. Do they have enough time between, you know, in that 6-month period to get all the documents and review done that they need done, draft their articles of amendment, draft their new bylaws, have the board approve it, and get it ready for that annual meeting? If the answer is no, then if there's no real reason why you really have to continue or transition at this time, wait until the next annual meeting. You've got another year, but it does give you plenty of time to really learn about this stuff and go through the process. A lot of people are doing really big governance and risk management reviews. Some people are doing strategic planning, and they're incorporating this piece into a much larger governance project.
Mm-hmm.
If you're a charity, also be really careful with your timeline. Canada Revenue Agency is in charge of registered charities in Canada. They approve your charitable purposes, and because your purposes have to go in your articles, be really careful when you're making any changes to your purposes if you're a charity, because you don't want to run the risk of getting everything approved and you file with the Ontario government only to have CRA reject your purposes when you file your articles of amendment with them.
Right. So with that in mind, it would be helpful to just take our audience through the applicability of the ONCA. Obviously, even just up to this point, we've referred in a few cases to the federal Not-for-profit Corporations Act, but maybe just take us through at a high level the applicability and who this does not apply to actually.
Okay. And so this is where, Myles, I messed up my slides in the order. So I'm flipping back to the deemed amendments and the non-deemed amendments. These are really crucial. I apologize for messing up the order of my slides, but okay. This part here where I was talking about, if you don't do the transition before October 18, 2024, your bylaws basically are going to be deemed to be amended to comply, right? So there are certain things that are so important that there are exceptions to this deemed amendment rule. And basically, there's a bunch of things that you have to put in your articles: your number of directors, your classes of members, your voting rights, and that sort of thing. So the transition provisions say that These things will not be deemed to be amended. You have to file articles of amendment no matter what. Even if you miss that 3-year transition period, these things will only be amended once you file articles of amendment. And the reason is that the government is not going to deem your actual letters patent to be amended. They're not going to do that. So this is going to cause, this part is going to cause the most headache and anxiety for people. Okay, did I skip it, Myles, where we were going?
We were at the applicability listing,
Yeah.
just showing the types of organization or the types of corporations there.
Yeah.
Just really maybe a high level there. And we'll jump-
Okay. So I've already kind of alluded to the applicability of the ONCA. It applies to Ontario corporations without share capital. They're called non-share capital corporations. So if you have a not-for-profit non-share capital corporation incorporated pursuant to Part 3 of the Corporations Act, you are now governed by the ONCA. Certain special act corporations, the ONCA applies to them, and those I don't have the, they're outside the scope of this presentation, but there are a few corporations in Ontario that are not for profit that have been incorporated by special act of the Ontario legislature. So the ONCA applies to them to a certain extent. We also have a type of organization in Ontario called social clubs. Again, this is very specific. It's outside the scope of the of this presentation, but really look at your letters patent really, really carefully if you're uncertain about the type of corporation that you have. Social clubs have to do one or more things within the next 5 years. And if they don't, they're actually going to get dissolved. So this is such a specialized thing. It's really, that's a whole hour presentation on its own. And so check your letters patent really carefully. As I said, the ONCA does not apply to federally incorporated not-for-profit corporations. So if your organization is governed by the Canada Not-for-profit Corporations Act, then everything that I'm talking about today won't apply to you. There are also cooperative corporations in Ontario that the ONCA does not apply to. And then the Corporations Act has other types of corporations, mining, banking, insurance, and all that kind of stuff. The ONCA does not apply to them either. We talked about the no deemed amendment, and this is a crucial thing for you to understand, that if you don't transition by October 18th, 2024, then potentially a big part of your bylaw is going to be deemed to be amended, and you're never going to know the difference because nobody's going to tell you. You just have to know. And that's going to be a really, really big problem for people.
Okay. And so that's an area where a particular note for our support organizations that are on the call here, or on the webinar, is in cases where we have member clubs or organizations that are part of our support organization membership, where they may in fact be incorporated entities. This is information that support organizations obviously can play a key role in helping support and lead their member organizations through this process. So hopefully these concepts and principles can be communicated, and our leaders can support that transition process of their respective members. So with that in mind, thanks for teeing up kind of the general structure in terms around the transition, the process itself. So like now to jump into some of the key concepts. Obviously, the ONCA in general terms can be somewhat overwhelming. And when we look at the work that we do as administrators in sport, this forms part of a very broad mandate in most cases. So the governance work is something that is so important for our organizations. It is the foundation for how we exist, and in order to do what we do within our sector. There's a couple of key areas within the ONCA that I've sort of been focusing a lot on, and I hear a lot from just in the conversations I've had with people, is around directors, the boards of directors, and how the ONCA might invoke some specific change in requirements to be amended. And then as well, member classes. So maybe through the next section here, we can focus on that. I see directors is up on the screen already. So maybe you can help take us through some of the key concepts there.
Okay, so there were some very specific rules relating to directors under the Corporations Act. And since about, I would say 2008, we were getting, the government was kind of relaxing some of those very specific rules. The Corporations Act really goes back to the 1800s, and corporate laws kind of evolved a little bit in the last 100 years. So we were trying to get the government to see that even while we waited 11 years for the ONCA, maybe they could make some changes to the Corporations Act while we waited. So in 2017, there were some changes made that are, were going to be reflected in the ONCA. So key concept is the ONCA requires at least 3 directors, right? I've said it previously, you can have more than 3. Most organizations will, but you can't have less than 3. You won't be in compliance with the legislation. And if you try to file articles with less than 3 directors, or you try to file a notice of change of directors and officers with less than 3 directors, you're not going to be allowed to do that. The maximum term for one term for a director is 4 years. Remember, this is a default rule that I mentioned before. Unless you say something different in your bylaws, each director has a term of 1 year. So you can accept that if you want, but you can't have a term of more than 4 years. That doesn't mean that you can't re-elect a director if that's what you want, if you don't have any, term limits in your bylaws and that sort of thing. But one term can't be more than 4 years. Historically, directors had to be members of a corporation under the Corporations Act. That's one of the things that we convinced the government to change over the last, 10 years or so. So under the ONCA, there's no need for directors to be members of corporations. And you might find in your bylaws that you've got weird classes of members with like one special class that's just for the directors. If you've got something like that in your bylaws, it's probably because of this old historical requirement that was under the Corporations Act until recently. So if you find weird things in your bylaws, sometimes it's because there were, weird things in the Corporations Act. Ex officio directors are acceptable. This is a difference between the CNCA. So an ex officio director is someone that is automatically a director as a result of the person's office. Okay, so the president of XYZ Foundation shall be a director of our corporation. And so what that means is that person is never elected by the directors, and whoever the president of XYZ Foundation is will be a director of your organization. And so as the president changes, so does the director. That's an example. 1/3 rule for board appointments of directors. This is another difference with the CNCA. The CNCA allows for this as long as you have the authorization in your articles. What this means is that there are some very specific conditions and legal tests that you have to meet or pass. And if you do, then the board is allowed to appoint a director to the board outside of members' meetings for in between members' annual meetings of members. Okay. This has real advantages. What I've found with working with the federal legislation for the past 10 years, it's something that's not very well understood by people. It's not a carte blanche for the directors to stack their board. at a minimum, the members have to have elected 3 directors at an annual meeting. And if they do that, and if other conditions are met, then the board can actually appoint somebody as a director, not for a full term, only until the next annual meeting of members. This is helpful to people, but it also prevents the board from circumventing the authority of the members, because election of directors is one of the key fundamental powers that members have. The number of directors I talk about a lot. So there's flexibility now. You can have a fixed number or you can have a range. A range, a minimum, maximum number, and a floating board all mean the same thing. Under the Corporations Act, you had to have a fixed number of directors, had to be a minimum of 3, and you increase or decrease the number of directors by passing a special resolution. I know everybody's got their number of directors in their bylaws, but that's not what the Corporations Act said. But now your number of directors goes in your articles. You have flexibility. You could have a fixed number, as I said, or you could have a range, minimum 3, maximum 21. Having a range provides real flexibility for the corporation, because the members still have to fix the number within that range, and they do it by special resolution, but it allows the organization to increase or decrease the number of directors on their board as their needs change without having to file articles of amendment. If you have a fixed number of directors, the only way to change it, so you have 8 directors and you say in your articles of amendment, number of directors, 8. 2 years down the road, you think, oh, we should really expand our board to 11. You can't just do that. You can't have the members increase the number of directors to 11. You have to file articles of amendment that are then processed by the Ontario government, increasing your fixed number of directors from 8 to 11 in your articles. And this is why I encourage people to have a range, because it just gives you so much more space without having to actually file articles of amendment. There's a new type of a corporation, or there is a type of a corporation in the ONCA now called a public benefit corporation, and I'm going to talk about that down the road. I have a little subpoint here where there's a restriction that for public benefit corporations, only 1/3 of the directors can be employees. Put an asterisk beside that. Be extremely cautious. Sometimes the act says you can do something. Well, that doesn't mean that you should. There's conflict of interest issues. How can an employee also be a director? Because the directors are the supervisors of the employees, and so then you're a supervisor of yourself. You're going to vote on pay increases and benefits and stuff. Doesn't make a lot of sense to me. If you're a charity, let me just say, really don't do it. You can get into a lot of trouble as a charity if you have paid people on the board of directors. Let's talk about members. Your classes of members have to go in your articles now. I think that there is some drafting errors in the actual legislation. There's 2 schools of thought here. One school of thought, which is the popular view, or the majority view, thinks that the ONCA provides for a default class of members if you only have 1 class of members, and therefore you don't have to create or establish that class in your articles. I disagree. I think that there are some drafting errors based on, I've reviewed the whole legislation. I could be wrong, but I think that you have to put your classes of members in your articles, even if you only have 1 class. If I turn out to be right, then, if I turn out to be wrong, there's no harm in creating or establishing your class of members in your articles. if I'm right and you don't have it in your articles, it's a really big foundational issue that could actually paralyze your corporation. So I'm taking the very, very safe route in this regard. If you have 2 or more classes of members, they have to go in the articles. You have to set out your voting rights, but then your conditions attaching to your members go in your bylaws. Unlike the CNCA, you can have pure non-voting classes of members. The CNCA allows even non-voting members to vote in certain circumstances. The ONCA did have those provisions and took them out before the legislation was brought into force. Now let's talk about public benefit corporations. Very briefly, the Corporations Canada, Industry Canada, the federal government, they created this type of corporation for federal not-for-profits called soliciting corporations. In Ontario, it's called a public benefit corporation. It includes basically what the government is saying is that if you're a charity, if you are an organization that gets government funding, whether it's federal, provincial, or municipal, if you are soliciting money from the public and you bring in all those sources, you bring in $10,000 a year or more, then you're going to be a public benefit corporation. And public benefit corporations should have more restrictions on them because they're taking money from the public, whether it's government funding, because that is taxpayers, or direct solicitation of donations. And the more restrictions really relate to financial reporting. Are you allowed to have an accountant, or are you required to have an auditor? An auditor is an accountant that has specialized training to be able to perform audit reviews of a corporation's financial structure. So your level of financial review might be more restricted. Are you going to be required to have an audit, or can you have a lesser financial review, which is a review engagement? To figure all of this out, you look at your financial statements at the end of your financial year, and you look at where your money is coming from. And if your money is coming from the public, and if it's more than $10,000 in that year, then as of your next annual meeting, remember, December 31 year end, you have to have your annual meeting within 6 months. So by the end of June the following year. So at that next annual meeting, you are going to flip into a public benefit corporations, and the bigger, higher restrictions will apply to you. This is going to be really confusing because you can flip in and out each year based on how much money you're getting from the public and that sort of thing. And it's one of the most complex concepts to understand, and it's one of the most important concepts to be able to understand, because it has to do with your finances, and it has to do with what kind of a retainer you have with your accounting firm, what level of financial review they have to do, and how much money you have to pay.
So this would be a great area, again, that might be overlooked by organizations, is to take the time to look at what those revenue thresholds are to determine what level of audit or review engagement would be necessary based on how you'd classify your corporation under the public benefit corporation status, correct? Okay, so then moving on, obviously the articles of amendment is going to be a key theme here through the rest of the conversation. There's a number of different potential amendments that corporations might have to make, particularly on the topic of the directors and the member classes, as you just talked about. So maybe just take us now through, as corporations are transitioning, what are some of those key amendments?
So section 103 of the ONCA provides you with a list of things that you can only amend by articles of amendment. Again, I think there's some drafting errors in the ONCA. This time, some of my colleagues agree with me on this point. There's some real inconsistencies between what you put in your bylaws and what the act says you have to amend by articles of amendment. It doesn't make any sense. We've put questions to the government. We're waiting for responses. So the standard rule is actually pretty simple. Anything that's in your articles can only be amended by filing articles of amendment with the government, right? Makes sense. In section 103, there's the approval process, which is basically a double approval process. The directors propose and amend, the members confirm and ratify. Once that happens, you can file your articles of amendment. Same process as applying for supplementary letters patent to amend the letters patent, but with not-for-profits, with the changes of directors, often, there's lots of people that have never been around an organization that actually has amended its letters patent. So there's you lose that corporate history or understanding, and it's just the nature of not-for-profits.
Kim,
So
just I hate to do this. I hate to take us back because I missed two questions in our Q&A. Just back to the public benefit corporation. You made the comment about public or revenue derived from the public. Could you just elaborate on what that definition of public funds would be? We've got two questions in the chat from John Ashworth and Kim. Money from the public, I assume that means donations. And then there was a question about, does sponsorship money fall under donations or?
Yes, and sponsorship money is a really big thing. So we're getting into tax. I am not a tax lawyer, nor am I an accountant. But this is a really big deal. Sponsorship money. If you have a contract with a corporation, government, and the funds are going to be characterized by your accountant as something other than a donation. If it's a sponsorship, that there's evidence that it's actually a sponsorship and it wouldn't fall into the definition of public benefit corporation by the type of funding. And this is where the accountants and the lawyers really have to work together, because it's not just a financial characterization of something. It's also a legal interpretation of something. The sponsorship may not be funding that would be included in that $10,000 threshold. The same is true if you are doing some work for a government agency and you've been contracted and there's actually a contract of services, then that's not necessarily, that's revenue. That's not a donation. That's not government funding. If you're getting a grant from a government agency, a grant is more likely to be the kind of financial assistance that would be included in that threshold of 10,000 of similar financial assistance. So it's donations from the public and similar financial assistance from the government. You have to look at the definition in the ONCA really, really carefully. We lawyers in the not-for-profit and charity sector, we have charts and all kinds of stuff. So this is a combination of accountants and lawyers figuring it out, helping you to figure it out. It's not simple. So if you receive more than $10,000 in a year, in a financial year, in the form of donations or gifts from persons who are not members, directors, officers, or employees, like outside people, or in the form of grants or similar financial assistance from a level of government. It's the grants or similar financial assistance that causes us the issues of how do we characterize something? Is it a contract? Is it a sponsorship? What type of a sponsorship? Does it go into general revenue, or does it get captured in this calculation of this threshold?
Right. Great. Thanks for that answer. And I think the key takeaway is that if there's any doubt, speak to your auditor or your accountant that works closely with your corporation.
And lawyer.
And lawyer, because each case may vary.
Right, because
there's
I'm
no
not an
blanket.
accountant, so I'm not going to prepare financial statements. And I'm not going to talk about, consolidated revenue and stuff. These are legal tests that have a financial and a tax implication. And we work with accountants all the time. I get lots of calls about things like contracts for services and stuff. So it's a complication, and it's going to cost you money to figure it out. And that's a really unfortunate part of it all.
Right.
Okay, back to amendments. So if you want to change your corporation's name, you can only do so by filing articles of amendment. If you have restrictions on the type of activities that you can carry on, or you want to add restrictions, you have to do that in your articles. If you want to make changes to your purposes, if you want to create a new class or group of members, if you want to change the number of directors. So I've talked about all of these things, right? These are the things that are required to be in your articles. You can only change them by amending your articles. In this slide, these are also things that are in that Articles of Amendment section in Section 103 of the Act. And this is where I think there is some drafting errors, because in Section 17 of the Act, it says you put your conditions of membership in your bylaws. Well, then why would you have to change a condition by filing articles of amendment? In another section of the Act, it says that you deal with all your conditions, including transfers of membership, in your bylaws. Why do you have to file articles of amendment to change that? All of these things have to do with members, membership, conditions, qualifications. And so the advice that I'm giving my clients is looking at this very, very carefully and comparing these provisions to other corporate legislation, like the federal not-for-profit legislation, the federal for-profit legislation, and the Ontario for-profit legislation, and coming up with a legal interpretation on the recommendations that I provide to my clients. And in the meantime, a group of us, I do a lot of work with the Ontario Bar Association. We have a working group that, we've put in questions to the government on some of the things that we think are problematic in the Ncaa that need clarification, or that perhaps are wrong. That's kind of what we do. So there are issues, and I really want to separate out these fundamental things that are always in the articles under legislation like the Ncaa, things that wouldn't necessarily have been in your letters patent, like the number of directors. Okay. So in Section 103, it says that you've got your double approval process. The directors propose and approve the amendment, and then the members confirm by special resolution. Once you get through that process, then you file your articles with the Ontario Ministry, and you pay $130. I've got some notes here, and the only thing that I'm going to look to point you to is the restrictions on changes of names. So you can't change your name if you're insolvent, basically. So there's tests that are applied. And so it's not just as simple as, hey, today we want to be called, whatever organization. there could be rules that restrict what you can do.
Great. So Kim, obviously that's a lot of information. We've only really sort of scratched the surface, I guess you could say. But as I mentioned at the top of the session, we will have some resources that we will be sharing with our audience members, a checklist that will take people through this, really summarize even more succinctly the content in our slides thus far, and provide you all with a checklist that you can use to navigate this process. So with that, let's shift over to the OBR. The transition, as you just described it, will require corporations becoming familiar with the Ontario Business Registry as a process to actually conduct that. So maybe you could take us through some of those steps and what people need to be aware of.
Okay, so we're going to talk. I want to talk about only two things: the company key and forms, the articles. I've got a handout that gives you some tips to prepare for the transition. And it's really, I focused on how to set up an account in the Ontario Business Registry. The reason that the Ncaa wasn't proclaimed for 11 years is because the Ontario government has been writing a brand new database. It's for all the corporations and other entities that it handles, and it's available to the public. Until the OBR came into existence, was launched on October 19th, 2021, the public didn't really have the opportunity to file things directly with the ministry. There was some level of interface, but not like this. As a lawyer, I always worked with a service provider, and I could file a lot of my stuff through a service provider, except for not-for-profit stuff, which I had to file directly with the government in paper in Toronto. So this is an electronic system. It's in, I think the first phase really is, it's meant for the public. I find it very confusing. I find it very awkward to work with. And one of the other sort of volunteer things that I've been doing since, I guess, a year now, is I'm helping the Ontario government with issues that have arisen after the launch of the OBR. And so I'm very familiar with the issues that people are having with it. What I want to say here is the idea is that you would go to the website that I pointed you to. You would request a company key, and that company key would be mailed to you, and you should get it within a couple of weeks. You need the company key, and it's a security feature of the Ontario government to try to prevent fraud. One of the problems is that whenever you convert data from one database to another, how big or how small the database doesn't matter. There's always going to be conversion issues. One of the conversion issues that we've noticed is with the addresses of the entities. And so if your address doesn't match up with what the government says your address is, then you can't get your company key. And you'll have to contact the ministry to try to get that sorted out. And what I've noticed with my clients that had this issue is some old address. In one case, a client said, "Oh, we haven't been at that address in 15 years. Well, I had to get that address fixed because the Ontario ministry, when that client's record was converted from the old system to the OBR, it populated an old address as the current address. And since that is the key thing that you have to have correct when you request a company key, you can't get your company key. I'm hoping that by now a lot of people have worked through that system. And there's a couple of things that you have to set up. In addition to requesting your company key, then you will, you have to set up a 1Pass, and you have to set up a Service Ontario account. And that's what that other document is for, to help you with that. So here's a link to the specific part of the OBR to request a company key. And as I said, the big issue is sometimes there's an old address that's put into the current address field, and it's a problem. The other thing that I wanted to point out, and I did point out before, is this is the direct link to the Articles of Amendment for Ontario not-for-profit corporations that you need to help you to complete for your transition. And in this filter, you'll have a document that's Articles of Amendment, and then you'll have a separate document that are the instructions for the Articles of Amendment. So you need to download both. If you don't have Adobe, and when you press the download button, and down in the corner of your computer screen, it shows you the document. If you don't have Adobe, it won't open, it'll give you an error. So you just have to go into your downloads folder on your computer, and then you can open up those documents that way. Okay.
Good tip. Kim, just before you carry on, so obviously this process, just by what you've taken us through thus far, can definitely come across as being quite daunting for organizations, for leaders. So I just know from my own experience, there's some practical issues that might arise. And as we look to work towards wrapping up our session today, no doubt there's lots of questions and thoughts on our audience members' minds. So I'm thinking that this next section might actually address some of those common questions and those issues or missteps that might come up along the way. So let's dive into what you think are some of the key practical issues facing our not-for-profit corporations.
Okay, thanks, Myles. So practical issues. Here's the process. Gather your current documents. Remember, I defined what constating documents are. So gather them, do a governance review, find your letters patent, figure out if you've ever amended those letters patent. And when you tell me we don't have letters patent, I will tell you that of course you do. If you're incorporated in Ontario, you will have letters patent. And don't worry, it's, you know, we get the question all the time. If you can't find the letters patent, you can order copies from the Ontario government. And so go on the Service Ontario website, or I didn't put a link in there, but you can order the copies of what is on record for your organization with the Ontario government. Get your bylaws, get your special resolutions. Remember, the only way to change the number of directors under the Corporations Act was to pass special resolutions. So you'll be needing to look at your minutes of your members, your minutes of your board, see what's in there. Did you change the number of directors by special resolution? Well, at one of your annual meetings, did you pass a special resolution at your meeting? So you need to gather all that stuff. Bring in your written policies, your manuals, all of your governance stuff. And then you really want to take a good review of it. Is this the time to update your governance structure, change your number of directors, change your eligibility, change your classes of members? There's, you know, is this the time that your organization is sort of going to evolve in a governance sense? Is it time? Are you working on a strategic plan? Are there lots of things to update? Is, like I said at the beginning, is this project part of a much larger project? And if it is, then take the time to do it. You don't need to rush. That's what I'm telling people. Don't rush through this. If you rush, you're going to make a mistake. And this is, as Myles said, a really daunting task anyway. So you might as well collect all your stuff, do a good review, understand. I had a client last year that was actually going to look at bylaws and stuff from US corporations for their Ontario corporation. So let me just say, please don't do that. It doesn't apply. You've got this jurisdiction that is the Ontario Not-for-profit Corporations Act, so you need to stick within that scope. Review the Not-for-profit Corporations Handbook, review the guide. With caution, review the ONCA default bylaw. Look at when you need to kind of do a compare with your letters patent and your bylaws with the changes that you're going to have to make because of the ONCA. So you need to look for those concepts and provisions in your current documents that are not going to comply with the ONCA, and then you have to decide what changes you need to make. Again, make this a larger project. What are your current practices? Is what you're doing in practical terms different from what your documents say? Happens all the time. I had a client that said, well, our bylaws say X, Y, and Z, and I'm reading their bylaws, and I said, where does it say that? Well, that's what it's supposed to say, the person said. I had a little chuckle over that. It's very, very common to have those disconnects between what your documents actually say and what you're doing in practice. So this is an opportunity for you to bring all of that together.
Definitely, is certainly in cases where organizations have had recent change in administration, whether that's the paid chief administrator, executive director, or at the board level. If there's been significant turnover at the board level, a lot of that institutional knowledge leaves, and while it's well intended, some of that information just doesn't get handed off or transitioned quite so appropriately. So it's a good point there.
There's another thing that I have found, and that is people don't get down on paper what's in their head. So they read into provisions, they read words that actually aren't there, that changes the meaning of the provision. So, clarity in writing and stuff like that. This is a project that needs to involve a number of people so that I need to understand what you're trying to say, right? And vice versa. So, two heads, two hands, a group, a governance committee, that kind of stuff. Very important. Okay, so I've already warned you about the default or the ONCA organizational bylaw, and I'm not going to spend a ton of time on it other than to say, it's pretty generic, treat it with caution. So throughout the presentation, you're going to find that I'm repeating myself, and I do that on purpose to use the same examples, the same subject matter, to try to create that sort of memory for you. So as I said, under the Corporations Act, you had to have a fixed number of directors. Under the ONCA, you can have a floating board now, which I always recommend because it creates more flexibility for people. The changes to the number of directors currently is done by way of special resolution. Most people can't find their special resolutions. They don't know that they need a special resolution. They've never known that they needed a special resolution. They've got the number of directors in their bylaws and they just changed their bylaws. So we kind of work with our clients. We look at the bylaws, we look at the minutes, we try to figure out, well, is it possible that I can find a special resolution in here somewhere? So find those special resolutions, look at your members' minutes, look at your directors' minutes and that kind of stuff. Number of directors has to be put in the articles. There are no ifs, ands, or buts about it. It's a mandatory rule, goes in your articles. Think about the floating board. Don't freak out about the maximum number. A lot of people do because they think that, oh my gosh, now we have to elect 15 directors. We only want 9. You don't have to elect 15. It just provides you with that cushion so that you don't have to file articles of amendment when you do make a change. Okay, once you've figured out all of that stuff and what changes you want, what changes you need to make, identifying the precise things that you have to put in your articles that do not go in your bylaws, and there are a number. Then you're going to draft your articles of amendment. The nice thing about the articles that the Ontario Ministry has created, there are some issues with them, I will say, but they are interactive. And so they try to lead you, you know, if you click X in this box, then you're going to get these 3 questions to answer. And if you click no, you're going to get other questions to answer. So they do try to, you know, they're very intuitive in that regard. I still have issues with them, but that's my job, right? To critique. So then you draft your articles of amendment. Articles of amendment amend your letters patent and supplementary letters patent, if any. Articles of amendment do not replace them. So depending on your particular circumstances, you may consider restated articles of incorporation, which will consolidate all of the provisions in your letters patent and all your supplementary letters patent. I have a client, the corporation was incorporated in 1921, and I've had to review their letters patent, and they've had 7 or 8 supplementary letters patent to figure out if I think they need restated articles of incorporation. It's kind of an intensive job. I don't think many organizations actually do need restated articles of incorporation, because I think you can do everything that you need to do and get rid of the old stuff and put in the new stuff by articles of amendment. It's a case-by-case basis. Okay, you're also going to draft new ONCA compliant bylaws. My recommendation is to just draft new bylaws that are ONCA compliant instead of trying to dither with and amend your current bylaws, because you're going to miss something. And you have to update all of your policies as well. I've got a handout that I prepared that OSN is going to send out to you that is a transition checklist, and it's obviously not 100% comprehensive. It's only like 5 pages, but it does try to alert you to different things that you need to think about when you're amending your articles and your bylaws. Because you have to get these documents approved by the board and confirmed by the members, you want to be careful with your policies, because your policies will tie in with your articles and your bylaws. If your organization, the members reject these changes, you don't want the board to have already approved a whole bunch of policies, which will then conflict with the articles and the bylaws that were rejected. So communication with the members is hugely important. Bring them on board, get them to understand that for many organizations, these changes are required or help the evolution of the organization, but obviously you want to work with your members so that when you do get to that members meeting, it's a slam dunk, unanimous vote in favor of the changes. I've talked about all of these things, the fact that this is a double approval process, being careful that you include all of the things in your bylaws or your articles that you need to authorize the way that you want to work, like timelines for meetings, like electronic meetings and that kind of stuff. Again, if you have any type of inkling that your members might not actually agree with the changes that you want to make, you need to leave time in your timeline between now and 2024 to address those issues. Thresholds for approval have to follow your current letters patent, supplementary letters patent, and bylaws. So if, let's say you have 3 different classes of members, and each of these things in your bylaws is to be confirmed by each member, each class of members. That's separate votes. That's a whole bunch of separate stuff that needs to be done. So you you follow your approval process based on, as I said, your current bylaws. Other issues that we've run across is organizations have a quorum so high that they actually can't meet it. So like, you know, majority of members, and you're never going to get a majority of your members to come out to a meeting, which it can be really problematic. So there's some challenges that you need to be concerned about. And the issue with quorum is always the toss up between what can we practically do to actually be able to carry on the business of the organization versus we really want member engagement. We really want our members to come out. If you have your quorum too high, and I've had this happen, you can't get enough members to a meeting to actually have a legally constituted meeting. So that's a problem, because then you can't do your business. I have lots of clients that have a class of honorary members and they've never tracked them. So if you have different classes of members, or if people haven't kept in touch, you need to find them so that you can validly get your stuff approved. If you're a charity, be really careful. I'm not going to spend too much time on this. But if you're a charity, really review that Not-for-profit Incorporators Handbook. It's very specialized. The Attorney General and the Public Guardian and Trustees Office in Ontario has jurisdiction over Ontario charities, in addition to the big authority of Canada Revenue Agency. So be really careful, understand where the public guardian and trustee needs to provide their consent for something. And I think that the Not-for-profit Incorporators Handbook is a good guide that can be really helpful to you in this process. After acquired clause is the only thing I'm going to talk about. So if you want to change, if you're a charity and you want to change your purposes, the Public Guardian and Trustees Office in Ontario has said, hang on a second, it's fine for you to change your purposes, but any money and property that you received prior to changing your purposes can only be used for your old purposes. The idea is that if you have your purpose is to relieve poverty by providing after-school sports events for at-risk youth, and you've solicited money for that, and you've gotten government grants for that and all that kind of stuff. And then you want to change your purposes so that it's relief of poverty, but your program is going to change to something other than an after-school sports program for at-risk youth. But you've got all this money in the bank that was given on the basis that that's what you were doing, the sports program. You can't use that money for your new purpose. That's what a lot of charities get themselves into difficulty, because they drift, and you can't just take in money and then put it in a general purpose fund and use it for whatever you want to use it for, right? As I said earlier, CRA has ultimate authority over your charitable purposes. So if you're going to be tweaking or playing around with your purposes, it might be a good idea to draft your purposes, send them into CRA for review, and wait until they let you know if they're okay or not. Problem with this is there is no service standard. There is no turnaround time. It could take a year and a half to get your stuff, to get any comments back from Canada Revenue Agency. So be really careful. That kind of strategically tells you or leads you to how you need to get this done. So
Kim,
once
I was just going to jump in there to say, and you've just brought it up. So, once we've worked through this process, we've completed all the documentation, and we're filing. Obviously, you're going to speak to some of that right now, but it'd be good to know as we bring this to an end, what would be next after that process in terms of communication of some of these constating documents? What do sport organizations need to do at the time of filing and post filing?
Okay, so following my train of thought with charities, this is a strategic step. You might not have, if you're a charity, if you're changing your purposes or even tweaking them, CRA needs to approve them. If you don't think that you have time to submit them in draft to CRA and wait for them to get back to you, you might decide that you're going to proceed to file your articles of amendment with Canada, with the Ontario Ministry, and then send them into CRA. And if CRA rejects your purposes, then you will have to modify your purposes and go through the approval process again and file another set of articles of amendment. But at least you'll be done the transition process from a corporate perspective with the Ncaa. So the transition, I say, remember, there's two steps. You've got articles of amendment, you've got bylaws. You've got what if we don't do anything and it's November 2024? Well, a lot of your stuff in your bylaws will be deemed to be amended, but your transition is not going to be complete until you file those articles of amendment, get your number of directors, your classes of members, your dissolution clause, all other required provisions into those articles of amendment. So once that's done, you file them with the Ontario Ministry through the Ontario Business Registry and pay your $130 filing fee, or I think it's still $130. Don't judge me harshly if I'm wrong. I don't think they've put it up to $150. That's the filing fee for articles of amendment for a business corporation. Anyway, the ministry will turn it around. They'll process your articles of amendment. If there's any issues with like form and stuff like that, your articles might get rejected, but you're not, they might get rejected. You have to clean them up a little bit. You resubmit them, fix the mistakes that the ministry tells you to fix. They'll process them. If you are one of those organizations that will also have to file restated articles of incorporation, you're working on those at the same time you're working on your articles of amendment. Your directors are going to approve, your members are going to confirm at the same time, and you're going to file them together, because the way that those two documents work, it's really technical, but your articles of amendment will be processed and then your restated articles of incorporation will be processed right after that. We talked about the deeming amendments. Again, highlight this in red. Be really careful. Just make sure you get your transition done if you possibly can before October 18th, 2024. So you get your stuff back. Obviously, you want to communicate to your members that the transition process is done. You will have to update your bank. Definitely, you'll have to send a copy of the certificate and articles of amendment to your bank. You probably don't have to send them your bylaws. The bank is going to ask about borrowing powers. Borrowing powers, unless the members restrict them, it's a statutory power now. So I don't even put borrowing powers in my bylaws, but if you do, the bank's going to want to see them, so you might have to send them your bylaws. You have to send your articles to your accountant, to your insurance company, to any regulatory body that might have oversight of your organization. If you're getting specific funding from a government agency, they may want to see a copy. Could be if you have a grant or some type of like I said, funding, there might be something in the contract that says that you have to provide copies of any updated constating documents to the funder. You'll have to look through your contracts and that sort of thing. Who you're dealing with, who have you previously had to send copies of your letters patent to, and then communicate appropriately with those agencies. But definitely, obviously, communication with your members to let them know that it's all done, and then learning to work with the new legislation, the new bylaws, the new governance structure. That's something, those growing pains often take a couple of years to work out.
Great.
And that's about it, Myles.
Excellent. Well, thank you so much, Kim. That was a really, really great overview of, like we've been saying, a very robust, complex subject. So I want to just take this opportunity to thank you for your time focusing on some of the key concepts and the principles of the ONCA, and drawing our audience's attention to many of the resources that are out there. And hopefully this is now another resource to them. We want to make sure that there's an opportunity. I think we've addressed the questions that we'd received in the Q&A. If there are any others, now would be a great moment to submit those. And we'll take a few minutes if there are any questions to address those here live. Otherwise, as we've said a few times throughout the session, there will be some resources coming your way via Ontario Support Network directly. So stay tuned for that, including today's presentation material, a checklist that will help guide you through the transition itself. And of course, reiterating where you can find some of these important resources and how you can complete this successfully. So I'm not seeing any questions coming through in the Q&A. So that might mean that you've done such a good job. You've answered everybody's thoughts and questions already, or people are being shy. Either way, that's okay. And with that, maybe I'll pass it back to, oh, I see one just popping in as I was talking.
One.
Yeah, it's the glazed over eyes and the holy cow, right?
Is there a downside to restating the articles rather than amending?
You don't have a choice. You have to amend. The restating of the articles goes with. It is not a substitute for.
Great. Good question and a simple answer. So thanks for that question there. We'll give it maybe another 30 seconds here. I'll try and fill the air, but conscious of everyone's time, you've given us just over 90 minutes, which we appreciate. And hopefully this has been informative for you, and we'll guide you as you work through the ONCA transition. Bianca, maybe I'll hand it back to you.
Yeah, so I just want to say thank you to Kim and Myles, of course, for joining us today and hosting this workshop for everyone. I do want to inform everyone who is in attendance that we do have a few more events coming up in the next few weeks or coming months. It's going to be a full summer of events. So on June 22nd, we will be hosting an event in person in Toronto, and it's going to focus on marketing. So it's a workshop that will cover sponsorship and social media. All those details are going to follow on our website this following week. And then also we will be hosting our first Sports Speaks event, which is like a sport panel talk. And that will be hosted on June 29th. And we will be talking about the state of sport today. So this is going to be a fun activity where we have the panel discussion that's going to kind of occur in the afternoon on the Wednesday. And it's going to be followed by a networking event where you can attend a TFC game. So your ticket will include the panel and also the TFC game. So it's going to be a very fun day, and it's just for the long weekend hit. So we're very excited for it. Again, all those details will be posted to our socials and our website this following week. Other than that, if that's everything from Kim and Myles, we will wrap up today.
Thank you very much, Bianca. Thank you, Kim, once again. Really appreciate your expertise.
And thank you for everyone attending. Kim?